My name is Juliet P. Kostritsky. I'm at the Case Western Law School, and it is our distinct pleasure today to announce that the school's Center for Business Law is sponsoring today's program. And we're extremely fortunate to have three incredibly knowledgeable and skilled business law practitioners from Tucker Ellis discussing the topic of current issues in LLCs with an emphasis on Ohio's new act. Now, a couple of administrative matters, and then I want to turn to introducing these three fantastic speakers. If you signed up for CLE, it should be approved soon, and you will be notified as to how to follow up to secure your CLE credit for attending today's program. In addition, if you're lawyers and you have questions, you will put them in the question and answer portion on Zoom, not the chat function. Okay, so this is the greatest thing to be able to introduce our speakers today. So Janie Juvan chairs both the Mergers and Acquisitions and Securities and Capital Markets practice groups at Tucker Ellis. She's also a member of the board of directors of Mace Security International, and they manufacture personal safety and security products such as Mace pepper spray. She advises investors, boards of directors, and management teams on corporate transactions, regulatory compliance, and fiduciary duties. She counsels public and high-growth private companies, private equity firms, and venture capital firms from initial formation through all stages of the business life cycle. She frequently can be found in the boardroom with directors as they make highly impactful and potentially transformative and confidential decisions. She is often tapped to assist corporate boards to maximize effectiveness and institute best practices. She's regularly called upon to advise corporate boards during the most challenging situations. She has also assisted activist shareholders in engaging with the board and management of struggling public companies. Whether making a decision to grow or divest corporate assets, clients in a variety of industries turn to Janie for her strategic advice on deals valued from approximately $5 million to more than $1 billion. So we're delighted to have Janie with us. Glenn Moracle, also from Tucker Ellis. He helps companies and their owners start, grow, buy, finance, sell, and exit their businesses. He's worked with businesses as diverse as financial services, manufacturing, retail, oil and gas, and software development companies. He guides public companies, broker-dealers, investment advisors, and private companies raising capital through the thickets of federal and state securities regulation. He advises banks and their holding companies on transactional and regulatory matters, such as raising capital, buying and selling loan portfolios, branches, and whole banks, and complying with supervisory requirements. Glenn often works with the boards of companies to make sure they are meeting their responsibilities and are positioned to defend themselves if challenged. With an MBA in finance and years of counseling clients ranging from entrepreneurs to senior executives of public companies, Glenn brings clients an understanding of their business needs and realities, as well as an extensive knowledge of the law. Dan Scheid, also from Tucker Ellis. It's a pleasure to welcome him, as he was a former student, and he's a business attorney now who focuses on the economics of each transaction. Dan's practice spans a broad range of business areas, including M&A, corporate governance, private equity, real estate and commercial finance. With a background in economics, Dan applies a practical, business-centric approach when counseling clients. His goal is to help clients see through the forest, see the forest through the trees, in even the most unfamiliar transaction setting. He represents buyers and sellers of various sizes and sophistication in corporate transactions. He's counseled both individual employee stock ownership plan trustees from the corporate perspective. He's also advised clients regarding bank mergers, including the acquisition of a national bank by a state chartered bank and the merger of two national banks and their holding companies, in each case with publicly traded stock as part of the merger consideration. In addition to corporate purchase and sale transactions, Dan regularly counsels clients in a variety of secured financing transactions, including representing both lenders and borrowers in project-based financings, as well as real estate acquisition, development, and sale transactions involving one or more parcels of land. With that, I'm going to turn the presentation over to Janie Juvan, Glenn Moracle, and Dan Shy from Tucker Ellis, presenting on Ohio's new LLC law.
Thank you, Juliet. Thank you to the students in the class. We look forward to chatting with you, and to everyone on Zoom, welcome. LLCs generally, but especially in today's business landscape, are some of the most commonly used entities for a variety of reasons. We felt that in light of Ohio's new action on this by adopting an entirely new LLC Act, we felt that this was a good time to explore the issues surrounding LLCs in today's landscape. And to do that, we're going to use the new Ohio Act as a vehicle. For the students in the class, just out of curiosity, could I get a show of hands of anyone here who's taken a business associations class or a corporations class? Okay, so a good portion of you. So you have some basic understanding, likely, if you've made it far enough through the class, of what a limited liability company is and how it may differ from the other types of entities out there. I just want to take a moment to refresh your memory of some of the more material attributes of those entities that will help during our discussion today. So first, as the name suggests, limited liability companies have limited liability for their members, i.e. their owners. This is a concept that, like corporations, the investors and the members who are holding interest in limited liability companies are protected from the liabilities and other claims arising out of the entity itself. You have to be aware of this, obviously, because of the piercing the corporate veil potential. But so long as you follow the corporate formalities required to set up an LLC and manage an LLC like a corporation, you'll be generally protected. The other interesting attribute of an LLC is it has a variable tax nature to it. So by default, when you form an LLC, so long as you have 2 or more members in the LLC, it is by default taxed as a partnership for federal purposes. However, the LLC is unique in the sense that you can actually elect to vary that tax structure. So you can elect to have it taxed as a C corporation, meaning it's subject to double taxation, or you can even go so far as to elect S corp status, which is applicable to both LLCs and corporations. As I kind of mentioned before, LLCs and the law surrounding LLCs is more prevalent, and that prevalence comes out of the fact that LLCs are generally more flexible than other types of entities. Even the prior Ohio Act, the new Ohio Act, and the LLC Acts in other jurisdictions all give a lot of deference to the contractual rights of the parties. So if you want to contractually arrange for a certain kind of equity structure, a certain kind of management structure, generally speaking, you will be able to do that with more ease in an LLC than you would in a corporation or a partnership. And with that, I'll turn it over to Glenn to talk about the new Ohio Act.
Before I turn to the new Act, Dan, I'd like to add a couple of footnotes to what you just said. Yes, an LLC limits the liability of its members to their investment in the LLC, but I don't want people to misunderstand that means somehow there's this cloak, this Star Wars shield that comes down over everything and protects everybody that's involved. One of my go-to examples, because I practice a good deal in the securities offering area, is if an individual goes out and sells investments in their LLC, and the investor purchases a membership interest in the LLC, the contract is with the LLC, let's say it's old school, they write a check, the check is payable to that LLC. If there is a violation of the securities laws in connection with that transaction, that individual is personally liable for the full extent of the investment. So yes, we talk about limited liability entities limiting people's liability, but it's not as sweeping as you might think. And the other fact is you can form a limited liability company and try to rent some commercial property for your business. And the landlord says, well, that's very nice, Glenn, but I don't want to rely on your LLC as being the only source of payment. I need your personal guarantee on the rent. So everything Dan said was accurate, but I don't want anybody left with the impression that somehow this is a cure-all for potential liabilities. Now let me turn to the new act in Ohio. And I understand a good number of students in the room may not intend to practice law in Ohio. So we are not trying to be, so nearly focused on Ohio that it's not going to be relevant to you if you practice someplace else. But this act brings into focus a number of things about LLCs and how they can, how they used to be in Ohio, how they will be in Ohio, how that compares to different jurisdictions, especially Delaware. And so we're going to try to give you a broader perspective than just the idea of here's what this act does. Now, having said that, where did this act come from? Well, most of the business entity laws in the state of Ohio are actually drafted by a committee of the Ohio State Bar Association. The Corporation Law Committee of the Ohio State Bar Association, actually, although its name is Corporation Law Committee, it drafts most of the legislation in the state for corporations, general partnerships, limited partnerships, LLCs, most of the commonly used entities. And so it's practicing lawyers who are volunteers who say, we need to do something about this statute and get together in a committee process. And this came through a subcommittee of the Corporation Law Committee. And it takes years to draft something like this. And this one is based on the ABA Prototype LLC Act. So it has a source now that is a common source, one you'd see around the country. The 1994 version of the Ohio Act was written from scratch in Ohio because there were very few LLC statutes that existed at all at the time, and no notion of a uniform or prototype kind of act. So what we did in 1994, when I say we, I'm on this committee in case it didn't come across. What we did back in 1994, was done from whole cloth. And Ohio's act was unique. It was the only act in the country that read the way ours did. Well, by going down the path now with the ABA prototype as the framework, it will look more like statutes in other jurisdictions, which is probably to our benefit. But in Ohio, we can't just take some uniform act or prototype act and copy it and stick it in our code book and be ready to go, because things like the way our Secretary of State does things. Our Secretary of State does things differently from the way a Secretary of State in another jurisdiction would. And so we have to have our law plug into that process. For example, one thing came in years ago when we were working on a partnership act. It was the first time the Secretary of State's office told me, when I was working with them on an act, said, look, we're gonna prepare forms that people have to use to make these filings. In many jurisdictions, I think most jurisdictions still, there are rules about what has to be in your filing, and you type up a document that you like and you send it in. In Ohio, you have to fill out a form for the Secretary of State. And one consequence of that is the original effective date of our act was delayed because the Secretary of State felt like their office just really wasn't going to be ready. The original effective date was going to be January 1 of this year. Okay, here we go, Socratic for just a little bit. Who can tell me what the effective date is now of the new Ohio LLC Act? Not all at once. I'm looking for both. I'm not calling on anybody yet. Bridget. Tomorrow. Okay. Today, in fact, this makes it a little bit challenging to talk about the quote old act and new act or the existing act, but if I say old act, I mean the one we're talking about today. If I say new act, it means the one tomorrow. But yes, we are on that cusp. And one thing about that that's a little different from some things we've done in the past is in the past with some of these entities, when we've changed the rules of the game dramatically, we have had a phase-in period to say, if you already have one of these entities, you have 3 years, let's say, to decide how, if you want to make changes in your entity to bring it in alignment with new provisions of the law. If you form a new one, starting now, it's going to have to follow the new rules. Well, under the act that goes into effect when? Tomorrow, every LLC will be governed by those rules. It's a big bang. It's, complete cutover. Every LLC that currently exists in Ohio will be under these provisions tomorrow. Everything newly formed starting tomorrow will be under the new act. So I'm going to hand it back to Dan.
Yeah, thanks, Glenn. And so one thing we wanted to do, so obviously we have this new act that goes into effect tomorrow. And so we wanted to kind of run through some common issues in limited liability companies and how the act may have addressed that concept, changed that concept, or provided a benefit through the amendments. So the first one that warrants some discussion is a discussion on who are the members of an LLC, right? So members in an LLC are the equivalent to a shareholder in a corporation or a partner in a general partnership. They are the owners of the LLC. In the LLC world, however, there is a nuance in that membership or ownership in an LLC implies that the member has both voting or management rights, so the right to make decisions, and economic rights, right? So they have the right to receive allocations of profit and loss from the company, and they get ultimately, if there's leftover profit at the end of the day, they get a distribution of that profit. In an LLC, there are also what we like to refer to, I guess, generally, although they can be called different things, as economic interest holders. So in an LLC, you can also separate the management rights from the economic rights. So you could have a person or an interested party in an LLC that holds quote unquote units in an LLC that have no voting rights whatsoever. They only have a right to a certain percentage of distributions or upon liquidation from the profits. What the new act has done in this area is added yet again another wrinkle, and it actually is an interesting wrinkle. What they have done is they have expressly stated that members, in order to become a member of an LLC, do not have to make any contributions to the LLC at the outset. Historically, membership always, had the implication that before you could become a member, you had to contribute either cash, assets, or provide services to the LLC in consideration of your membership and admission to membership in the LLC. What the concept of not requiring any sort of contribution from members seems to suggest that you could actually have a voting interest and be a member in an LLC without having any attached economic interest, right? If you don't put anything into the LLC, why should you be entitled to get something out of the LLC? Similarly, the new act has also provided that you can actually provide enforceable rights to third parties who are not members and who have not signed the operating agreement put into place. So let's talk about a practical reality of where this could come up, right? One thought is a special purpose entity for real estate finances. So in the real estate world, if you're buying a piece of real estate and you want to go out and find a lender to lend you the money to go and do that acquisition, right? Typically, commercial real estate lenders will require you or ask you to put the piece of property that you're buying into a separate entity, typically an LLC, that is within the large organization. So you're segregating the real estate asset into a separate entity down in the structure. And the idea from the lender's perspective is they want to protect that asset from an overall bankruptcy scenario, right? They want to confine the asset to a single LLC, protect it, and then that LLC is collateralized via a mortgage and other, potentially a pledge of the membership interest in the LLC, et cetera. So what this provision can actually do for a lender, it actually gives them more teeth to their loan. If they're not satisfied with the amount of collateral they're getting in a loan transaction, they could actually say, I want you to provide me some right, for example, to have an independent person on your board who has a blocking right or a consent right to taking certain actions. So for example, if the LLC is undergoing financial difficulty and they're thinking about filing for bankruptcy, the lender obviously doesn't want that. So they can have a blocking right for that ability to voluntarily file for bankruptcy to prevent that from happening. So that's just one area where it could come up, but it's an interesting concept when you're structuring, and especially in the commercial and real estate lending context where this actually may be used in the future. The other concept,
if I could just interject,
yeah.
this idea of that member without an economic interest who might be put in place because of a lender trying to protect their rights. That is not just some theoretical idea. The most recent time I've seen it was last week in my practice.
Yeah. And actually, Janie, not to put you in the spot, but do you want to kind of just quickly mention your experience on a recent deal you worked on?
Yeah, sure, Dan. So we had a recent deal where one of the key individuals was under a non-compete that was specifically worded, and he could not have governance rights in another LLC without tripping his non-compete, but it was structured so that he could have economic rights. So because of this bifurcation, we're allowed to make him an economic interest holder without having any governance rights in the entity. So yeah, so the flexibility can definitely help from a transaction structuring standpoint. And when you're advising clients, it's important to know of the nuance, because if you didn't, you might tell him that he couldn't participate when in fact he was able to in a very compliant way.
Thanks, Janie. So another concept that I want to quickly address that kind of touches on the concept of ownership is the concept of management in an LLC. I want to touch on this briefly, but historically in Ohio, at least, Ohio has been pretty rigid in keeping to the traditional structure of having an LLC managed as a member managed LLC or a manager managed LLC. What that means is, in essence, that either the members who actually own the interest would be involved and making material decisions regarding the organization, or you would actually appoint a manager, which is a term of art, to run the LLC to make material decisions. I think in practice, and especially more recently, a lot of us have viewed that, especially based on some of the common law decisions, at least in Ohio, that had some flexibility to it in and of itself, whereas you could actually create, rather than one manager, you could create multiple managers, or you could create a board of managers who actually act like a board of directors. What the new Ohio Act has done is actually expressly codified the flexibility there and stated that you can have a member managed LLC, you can have a manager managed LLC, or you can have another form of organization that you agree upon. And so it really allows you to expressly deviate from those rigid structures and structure an organization that runs how the people agreeing and signing the operating agreement want it to run.
Dan, if I can interject some history from the perspective of somebody who was around in 1994 when we put in the existing act, and when LLCs really first came into being a practical form. When I started practice, LLCs didn't exist. And they came into existence, there was this fantastic tax result that you could have limited liability and have flow through treatment for tax purposes. There was like, wow, this is sliced bread. We need to do more of this. And the statutes came into place. But up to that point in time, generally speaking, you either had a corporation or you had a partnership. Well, in a corporation, the owners don't run the place. They elect directors, and the directors elect officers, and on a day-to-day basis, officers run things, and the board is in charge. And in many corporations, the shareholders only get involved, rarely in voting on electing the directors, for example. On the other hand, in a general partnership, all the owners are part of management. Every partner is equally entitled to have a say in how the place is run. And now we have this new entity, this LLC thing, and we're like, okay, which one is it going to be like? And so people had in their heads kind of two buckets. There was the one where it's member managed, it's like a partnership, everybody has their say. Or, oh wait, no, we're going to make it more like a corporation. The owners are not going to be the ones running. So that's how we kind of got that dichotomy. And of course, it's morphed over the years.
I agree with
And
that.
I particularly like the fact that it's expressed that you can have a board of directors, and in your operating agreement, even opt in to say, we want this entity to be run like a corporation, but we're taking advantage of some of the other attributes that come with an LLC, because there can be certain circumstances where the governance framework of a corporation would be more appropriate for what you're trying to do than the governance framework of it being, let's call it, member managed. So I like the fact that the LLC Act is expressed on that point and gives you that flexibility.
Right, and I have to work in somewhere the fact, my favorite saying about LLCs is the best thing about an LLC is it's remarkably flexible. You can do almost anything you want. The worst thing about an LLC is remarkably flexible. You can do just about anything you want, which means, when the client comes in and says, oh, I want the usual, there is no usual. There are categories, I guess I would say, but the amount of flexibility in this kind of organization can be a great challenge to the lawyers, because it's almost like writing on a blank slate, as opposed to having tight ground rules you start with.
And when a client says, I have an LLC, don't make any assumptions in terms of what that means. You need to look at all of the governing documents, all of the tax documents, the entire corporate record book to know what exactly it is that they have.
Jeannie, do you want to touch on fiduciary duties?
Absolutely. And before we get there, I want to make a point. Glenn mentioned the concept of a personal guarantee. And he said, you know, even though we have this limited liability nature of this entity, if you have a personal guarantee, you personally could be on the hook for anything that you sign for. When I was a brand new lawyer, and I'm dating myself, it was before 2008 and the financial crisis, I saw an individual give a presentation about the remarkable success that her company had. And then 2008 hit, and everybody knows that story where it was a complete financial collapse and her business didn't make it through, and it took her down with it because she had signed a personal guarantee. My sense is that some of you are going to go on your journey and become lawyers. Some of you may be getting an MBA today or may get one in the future and go on the business side of things. I would just encourage you, if you're ever in that situation where you're starting up a business and you need capital, to do a lot of shopping if you can, to try to avoid that personal guarantee so that you're not in a situation where you are on the hook personally if your business isn't performing. I think honestly, if you walk away with only that one point today that Glenn was making, that's a good lesson in and of itself. So I'm going to look at these entities from the governance perspective. That's what I focus on primarily in my practice. And I want to take a few minutes to talk about why it is that we have a fiduciary duty construct and when that construct applies versus when it doesn't apply, particularly given the new act. When doing business with others or making an investment in a company, it's vital that you consider what duties the owners and managers or directors owe to each other, and that you have that understanding, because there's not a one-size-fits-all governance framework anymore. There are lots of different nuances to governance today. Fiduciary duties are the standards for how people acting on behalf of the organization must behave for the benefit of the organization, and how controlling business owners must behave when taking actions that impact the other owners. I personally have served on many boards. I've served on everything from nonprofit boards to a board of a publicly traded company. All of the boards that I have served on have been fiduciary boards. I highly recommend, if you're interested in business law, that you serve on a board, even if it's a nonprofit board to begin with, to get some experience and use that as a stepping stone to either a private company board or a public company board. When you're on the board, you quickly realize that you're responsible for oversight and setting the strategy of the organization, and the board makes material decisions that impact the organization. When you're on a fiduciary board, meaning that you do have fiduciary duties, I like to say, are at the center and the core of every single thing that we do. Anytime I'm on a board, a fiduciary board, and I'm making a material decision, I ask, what is the duty that I owe either all of the stockholders or the stakeholders in the organization? And I look at the decision through that lens. And the question will come up, can I favor one stockholder over another? Could I favor myself over other stockholders or stakeholders? And the answer is typically no, that you can't. You have to look at it as a whole. The types of decisions that the board is considering are oftentimes whether to enter into a material acquisition, who the executive leadership team of the organization should be, and in particular, the chief executive officer. The board, oftentimes through the comp committee, is evaluating the performance of that executive leadership team. And there are also instances where the board will either oversee or form special committees to oversee corporate internal investigations. So the board's making some really important decisions for the organization. Now, in looking at the traditional construct of fiduciary duties, there are two main fiduciary duties that we talk about. The first is the duty of loyalty, and the second is the duty of care. I'm first going to talk about these traditional fiduciary duties, and then I'm going to talk about fiduciary duties in the context of the new Ohio LLC statute. Under the duty of loyalty, a person must make decisions in good faith in what they believe to be in and not opposed to the best interests of the organization as a whole. A person should not be influenced by their own personal interests that conflict with the interests of the organization or the other owners. I like to say when you step in the boardroom, you have to leave your own personal interests behind, and you're looking primarily at what is in the best interest of the organization and what is in the best interests of the organization's stockholders or stakeholders. If you can't do that, if you have a conflict of interest, you have a duty to recuse yourself and not participate in the deliberative process concerning that particular issue or any voting on that particular issue. So it's critical when you're serving on a board that you're putting the interests of the organization ahead of your own, and that you be disinterested in the matter under consideration and be independent in reaching a decision. With respect to the duty of care, I tend to say that this is a duty that applies to the board as a whole and is less of an individual duty the way that the duty of loyalty is. And the board must act with the care that an ordinarily prudent person in a like position would under the same or similar circumstances. I think it's critical in fulfilling this duty that you make sure that you act in an informed and thoughtful manner. And that means that before you go to board meetings, you're gathering information, you're reading and reviewing that information and any information that's given to you as part of your board materials, that you're doing your own due diligence, and that you're really questioning what's going on and what's best for the organization. You do have that duty to inform yourself of all material information reasonably available prior to making a decision. Process with respect to the duty of care is critically important. So act in an orderly manner without undue haste. If you're considering a material transaction, for example, you're going to have possibly multiple board meetings before you make a decision and consider it from all different angles in terms of the pros and the cons, and debate and deliberate that with your fellow board members. You'll obtain summaries of key documents to make sure that you understand the transaction terms. And I always like to say that good directors ask questions and ask questions and ask questions. And then what's key in terms of making sure that you're demonstrating compliance with your fiduciary duties is that you're documenting what you've done as part of your meeting minutes in an appropriate and thoughtful way that's protective of the board, but doesn't create a script for a plaintiff's lawyer if they want to sue you for breach. There's a lot to that, but that would be a whole hour in and of itself. Now, when we transition from this traditional construct to member fiduciary duties under the new LLC statute, the new LLC statute, first of all, Ohio is different than Delaware in that we have fiduciary duties that are laid out in our statute as opposed to simply by common law. We have statutory fiduciary duties. And the new statute distinguishes between member duties if there are managers, but the managers aren't the members. So those would be third-party managers. Member duties if there are no managers. So the members are the ones who are actually running the organization. And then manager fiduciary duties. In this context, under the new statute, if there are members who are not managers, they only owe the implied covenant of good faith and fair dealing. They don't owe any other fiduciary duties unless the operating agreement calls for additional fiduciary duties. If there are no managers and the members are running the organization, then there are fiduciary duties that would kick in, and it's the duty of loyalty and the duty of care. The Ohio statutory language is similar to what I outlined to you previously. I won't go through it all. You can take a look at it. It's not identical though. And if I had one criticism of the act, I would say that it might have been better to look at some formulations of these duties from case law, possibly Delaware case law, because I tend to be very pro Delaware, and I like the writing coming out of the Delaware Chancery Court and other Delaware courts. I think we maybe could have done a better job in describing the duty of loyalty in particular. But it does generally track the essence of what I had told you previously. With respect to the duty of care in this context, it's limited to refraining from or engaging in grossly negligent or reckless conduct, intentional misconduct, or knowing violation of the law, which is a fairly high standard. And that's when members are managing the organization and there are no managers. In terms of manager fiduciary duties, if you don't expressly articulate them in your operating agreement, the duty of loyalty is the same as the duty of loyalty that applies to members when they're managing. The duty of care is different. It's a lower standard, or higher, depending on how you characterize it, but it's limited to acting in good faith in a manner the manager reasonably believes to be in or not opposed to the best interest of the LLC. So the manager has to do more to demonstrate compliance with the duty of care. Now, in terms of the new act, there is an ability to completely disclaim these fiduciary duties and say that no one in the organization owes fiduciary duties to anyone. This can be especially important, for example, for investors who are members and managers of multiple investments, some of which may be in overlapping industries. If fiduciary duties were to apply, these individuals may be in a situation of conflicting fiduciary duties. And so for them, from an investment standpoint, it's best for them to participate in entities that don't have fiduciary duties. So that's one example where this can be a real benefit. Now, even though you can wipe away all of these fiduciary duties, the one thing that Ohio and Delaware agree on in this context is that you can't wipe out the implied covenant of good faith and fair dealing. And you'll hear that some people say, oh, this is a fiduciary duty, but it's not a fiduciary duty. It's actually a contractual principle. Ohio law imposes an implied covenant of good faith and fair dealing in every contract so that one party does not unfairly take advantage of another party. This is the one covenant that cannot be waived and is essentially a gap filler in the event that an operating agreement doesn't specify a term on a particular topic. Courts have interpreted this very narrowly, though, and have said that if an operating agreement speaks to a particular issue, they typically will enforce the language of the operating agreement. So to me, it's the unwaivable but waivable implied covenant of good faith and fair dealing, because if parties are express about what they are allowed to do, even if it seems like it might not be compliant with the implied covenant, a court may enforce their language. So Glenn, I want to kick this over to you. An investor engages you. He says he's about to make an investment in an Ohio LLC, but there's a complete waiver of fiduciary duties. The lawyer for his co-investor says not to worry. He still has the protection of the implied covenant of good faith and fair dealing, which the lawyer says is essentially a fiduciary duty, and says that your client has a lot of protection. What do you say?
Nonsense. Would you like for me to elaborate?
Yes, please.
As Janie has just said, the implied covenant of good faith and fair dealing is a gap filler. If the agreement allows someone to engage in a particular activity, the courts generally will look to that and say, well, you've agreed to that. That behavior was defined by the, I would say was defined by the agreement, at least implicitly, as being fair dealing. If your agreement said they could do it, then you cannot object to that. And there's also, the law in Ohio is also that you cannot claim that the covenant of good faith and fair dealing has been breached in the vacuum. You can only associate that with a claim of breach of contract. If you can't point at something in the contract that the party is not doing as the contract said, or they're doing in contravention of what the contract said, If you can't point to that breach, you can't have a claim for the implied covenant. So I think the implied covenant, it has some application for people who have, I don't know, sort of skeletal documents, and you really need to make sure that, you know, the things that were not addressed, we have to behave fairly. But the things that have been addressed clearly, unambiguously, that agreement's going to control.
And we've actually drafted provisions where someone wants to protect themselves and wants to be able to act in their own best interest as opposed to the interest of other investors, and have said expressly, the manager shall be entitled to consider any such interests and factors as he desires, including his own interests, and shall, to the fullest extent permitted by applicable law, have no duty or obligation to give any consideration to any interest of or factors affecting any other investors. The manager may, in his sole and absolute discretion, appoint friends or family members or to board and officer provisions. In doing so, shall not be a breach of this agreement or any applicable law, standard, duty, or covenant, whether express or implied. So that's language to get around the implied covenant, and it could be subject to challenge. It would be interesting to see. I don't know that that specific language has ever been tested in the courts, but it would be interesting to see where they'd come out. But I do think that that approach is pretty strong, given precedent. Even if you waive fiduciary duties, my one last point in this area, minority investors can still negotiate for other protections. They can designate somebody to the board if they're able to negotiate and get that. And if they're not able to get a board designee, they could negotiate for board observer rights. They also could negotiate for special approval rights, where if an organization, for example, is going to take out a loan, they could say, I don't want you to take out a loan that's material in amount without my consent. They can negotiate for information rights, and they can negotiate to have their interest put back to the organization in certain instances that are pre-negotiated, or they could negotiate that if there's a sale of the company, that they would have the right to tag along and join the sale. That's at a very high level minority protections, but there's a whole package of minority protections that you can put in place in the event you waive fiduciary duties, so that your minorities still feel like they're protected in their investment. And with that said, I'll turn it back to Dan and Glenn.
Dan, before you pick up, I just very quickly like to say the whole nature of the flexibility we've been talking about here, and the increased flexibility under this act, means that the person with knowledge and bargaining power has more opportunities to do things. The person who is unaware of what's at stake or doesn't have the bargaining power to get what they want is going to be at the, they're going to be disadvantaged by the amount of flexibility in the act. So it's hard to say whether the act is a good thing or a bad thing. It depends on, it depends on where you are on that spectrum.
We're running low on time, but there was a couple other points that I did want to comment on. The first of which is I want to touch briefly on talking about restrictions on transfer of interest in LLCs. So first question that might, especially for the students in the room, why would you want to restrict who can transfer their interests, especially their ownership interests in an LLC? And the answer is, especially in closely held LLCs, is that they want to control who's in the club, right? They don't want to agree to enter into a, go into a venture with two other partners, and then one of the two partners immediately turns around after they start the process and sell their interest to some third party they don't know, right? And so historically in Ohio, common law has provided and supported that you can implant restrictions on transfer in your operating agreement, and they will be, generally speaking, upheld. What does that mean? So that means if I want to go sell my interest to Sierra over here, I would have to typically go get consent from my partners, or I would have to go through a process, like a right of first refusal process, where my partners have the chance to buy my interest back. What the new act has done now is the new act has expressly codified that those restrictions on transfer are enforceable, as if there was any question before. And so it just lends credence to the fact that you can draft heavy-handed restrictions to ensure that your interests and your partner's interests stay within the group of people that you know and you trust. The only other thing worth mentioning as well is in line with can you provide for a penalty if someone breaches an operating agreement, right? Historically, I think people have gotten pretty creative with this, and I see it in practice where you have different provisions that say, hey, if you do X, Y, and Z in breach of this operating agreement, you're going to, have to forfeit your interest, you're going to have to pay a penalty, you're going to have to offer to sell me your interests, etc. And I think some of those, especially the more heavy-handed ones, probably haven't been tested. And if they have been tested, I don't know that there's a clear, bright line rule for whether every court was going to uphold it. The new act, in those instances, has expressly said that yes, we will uphold those restrictions on transfer. And so, going back to Glenn's original point, the person with bargaining power has all the power to dictate what's going to happen if someone trips up on one of the provisions of the operation agreement.
Shall we turn to series LLCs? Is that where we are? Series LLCs are a brand new concept starting tomorrow in Ohio LLC law. They've existed for some time in Delaware. And honestly, the draft bill that came out of the Ohio State Bar Association for this new LLC Act did not include series LLCs as part of the act. The committee did not think it was something that was important for Ohio to adopt. But the legislative process being what it is, one of the legislators, who I understand, not a lawyer, never practiced, but he'd heard that a series LLC thing was, that was a good thing to have. And he said, we should have those in Ohio. And so it got drafted into the act and now they're provided for. I can tell you, I think without betraying confidences, that the people who actually wrote the new act in the Bar Association are saying, I wouldn't advise anybody to try to form an Ohio series LLC for the time being until we have some experience and the courts have tested these things. We're not sure how they're going to work. And I realized I leapt right past the point of what do they do? And that is a series LLC can have essentially what I'll call silos in it. That you can have one LLC and it puts assets and operations into this silo and different ones into this silo and different ones into that silo. And even though technically it's one LLC, a claim again that arises from the operations in silo number one won't affect the assets. That liability will not attach to the other assets. And that can be very useful if you're running an investment fund that has different portfolios with different strategies, and you want to keep those separate. That's the way mutual funds work. They're usually in a very specialized kind of trust, but we see private investment funds that are in series format in LLCs that are trying to keep their portfolios in these different silos. My personal advice is, for the time being, until we have tested the statute in Ohio, if you want to do that, do it in Delaware.
I agree with Glenn. I think that's a good recommendation because there's one thing that clients consistently don't like, and that's the element of surprise. And these have not been tested in Ohio, or if it's an Ohio LLC, a series LLC, they haven't been tested in other jurisdictions in terms of whether that corporate protection would hold up. And you don't want to be the one recommending that your client use it and then find that someone, some court is going to decide that the corporate protection is not enforceable for some reason.
Well,
so might be best to let someone else test the waters on that one.
And we've also found that commercial lenders, confronted with the idea of whether they want to rely on the idea that those assets will be kept protected in this one space, similar to the special purpose vehicle that Dan referred to before. Lenders are leery of relying on a new statute like this to be assured that when they make a loan and it's supposed to be secured by assets in silo number one and it'll never be hurt by what's in silo number two. The regional lenders here, I'm pretty confident, are not yet ready to go down that path. So your client might think it's a great idea, but they go to the bank and it's not going to work.
Yeah, and Dan does a lot of our work on finance and M&A, so he has that dual skill set, which definitely is great for us. And I think he'll tell you that when we're trying to get a deal closed, the last thing that we want is the lender pumping the brakes because they're not sure that they're comfortable with the creative and fascinating series LLC structure that we decided to put in place. That could be a disaster. Dan and I usually work together to try to make things as simple for lenders as possible so that this is just a check the box exercise. They ask, we answer, we get our funding, and we can get our deal done.
Under issues have been the flavor of the last couple of months, I feel like.
Yep.
One other thing I just want very quickly to comment on, and it was something Jeannie said, and it was just to give a better example of why using a series LLC in Ohio might be risky. Consider a scenario where you form an Ohio series LLC. One or more of the silos goes out and starts doing business in Indiana or Illinois, for example. And Indiana, well, at least let's use Indiana because I know they don't have the series LLC concept. They get out of those operations in Indiana, they get sued, and they're claiming that there's no limited liability. That just because silo one's operations were in Indiana, I can come after all the assets of all of the series. That's a scenario where we don't know how Indiana courts are going to interpret Ohio's, and the concept of a series LLC.
Okay, actually, this comparing Ohio and Delaware on some points like this, I think is a good springboard, a good transition to the general subject of why would you choose one jurisdiction over another to form an entity? And I think there's an inappropriate prejudice among many people to say, oh, well, Delaware's where we form entities. Delaware's done a fantastic job of claiming that turf, so to speak, building up their image and saying, you're going to form an entity, you got to come to Delaware. I think that is exaggerated, frankly. If you have a potential LLC that's going to have a handful of members pretty closely connected, operate locally here, there's no great reason to run off to Delaware to form it. There are definitely advantages to Delaware if you have a more complicated organization, more owners, more diverse interests, shall we say, and especially if you may end up litigating over those issues. And I think Janie, well, you heard Janie say earlier, she's a big fan of Delaware. I think she's more a fan of Delaware than I am. We're not at quite the same place on the spectrum, but we're not as different as it might sound. So Janie, tell us about why you lean towards Delaware.
Well, it's not just because they give us fascinating reading material for Friday nights, but I'm in favor of it because the law in Delaware is so established. And when I was the vice chair of the ABA Corporate Governance Committee, there were a lot of members of the Delaware Bar on our committee. And, Delaware is a state where one of the primary industries is corporate law. This is what citizens in Delaware do, a lot of them. And, because of that, they have a judiciary where they have exclusively judges who look only at corporate law issues, who are experts in corporate law issues. So number one, the case law is very defined, which helps with predictability, certainty, and decreases that element of surprise. And another reason then is if there is a dispute and I need to litigate an issue, I'm going before judges who understand these issues and do it for their career. I don't have to educate them for the first time. Now, Glenn, not to steal your thunder, will say there might be circumstances where I don't want the judge to be as knowledgeable and maybe I want to be the one educating them. And I think that's a fair point. But typically, especially when you're looking at sophisticated transactions with big dollars on the line, there's nothing better than having that established framework in place. And in Ohio anyways, if there's a gap in Ohio law, Ohio judges oftentimes will look at Delaware and try to interpret Delaware law. And if Ohio judges are going to do that anyway, then I would say better to go to Delaware, where they're the ones who have actually established the framework and probably know it better. So that's the flip side of the coin.
And I agree with all of that. Some of you may be aware that there was sort of an experiment in Ohio previously to establish commercial dockets, not technically different commercial courts in Ohio, but there were dockets established in several counties that if you had a commercial case, it would be directed to judges who had been considered qualified for the commercial docket. I was disappointed in how some of that played out because the attitude of the judges that were on the commercial docket was their main job was to move things fast. And it didn't matter whether they had any idea how commercial transactions worked. What Jane's referring to, the Chancery Court in Delaware, those people handle commercial cases day in and day out. They don't have a drug case or a murder case and then a corporate case. They're only doing business entity cases and are therefore very knowledgeable in that arena. And there is a movement within the Ohio State Bar Association. The OSBA is working again on trying to get a commercial docket system workable in Ohio, but it's probably going to take years to get there. And even if we get there, it's not going to have all the benefits that the Chancery Court in Delaware has.
Even if we get there, we're still 20 years behind, Glenn.
Well, we've almost run out of time even before
Yeah,
Zoom, but do we have
one
any questions?
question, at least that we can have time for. So here's a question from Callan Foran, who asks this question. Are fiduciary duties of non-contributing members scrutinized more or less strictly than members with an economic interest? Additionally, is a different standard of the duty of care applicable in relation to individuals with only an economic interest?
Interestingly, I would say that it depends, because ordinarily with fiduciary duties that apply, I would say that it's not relevant whether you have an economic interest or not. So for example, if I'm on the board of a public company, but I don't own one share of stock, I owe the same fiduciary duties as somebody who owns, 75% of the stock. It's the same. Now, what is interesting with the Ohio LLC law is it does give you the flexibility to define whatever fiduciary duties you want. So I could anticipate a framework where somebody would say that you have a higher fiduciary duty in one circumstance over the other, if that's what the parties would negotiate. You can define fiduciary duties, it seems like, however you want. You can expand, modify, or waive fiduciary duties under the new act.
And one other thing that popped into my head is, so in the case that we were using, the example we were using earlier, where you have a lender who wants to have some rights to enforce or potentially some voting or management rights without the economic interest, is could you potentially have a lender also demand that there's a duty in there to act in the best interest of whatever preserves the value of their collateral? Sometimes those two things go hand in hand, but not necessarily always. And so there's interesting questions that could come up there.
And that's the second thing, though, that I would say, the personal guarantee was one, but the second is if you can keep your lender out of the boardroom, you might prefer that, because the key is having that be passive capital, if at all possible, and not having the lender being the one to drive the decision-making of your organization, because they're there to protect the money that they've put in. They're not, I guess it depends, right, on who's in your boardroom, but they may not be the right person to tell you what steps you need to take in order to grow the organization, or what risks you need to take in order to grow at the rate you want to grow at.
And Janie, this reminds me of an area of law, body of law that developed over years and kind of flip-flopped some in Delaware about the question of whether as an entity approaches the so-called zone of insolvency, and it might be that, okay, the shareholders really are no longer the ones who are going to make or lose money based on what decision gets made. It's really going to be the creditors. Are the creditors the ones whose money is being spent? And there were decisions that essentially said the duty of the director is now kind of shifted over to have to protect the creditors. Well, there is case law in Ohio based on our particular statute drafted by the Corporation Law Committee of the State Bar Association that talks about the duties of directors and the constituencies that they represent. And it never mentions duties to creditors. And there are not very many cases, but there's at least, there are a couple of cases. I think they may all be federal cases applying Ohio law, but where judges have said, we're looking at this statute, it never mentions that the board could ever have duties to creditors, therefore no such duty exists.
Mhm. Yep. And then the other interesting point with that analysis, when there is that zone of insolvency, is when do you enter the zone of insolvency? Because there can be a lot of gray in terms of whether you're in that zone or whether you aren't in that zone. And that can be very difficult for directors to wade through when you're not sure to whom do you owe your fiduciary duties, whose best interest should you be acting for the benefit of.
So on that note, I think we're at the end of our time.
You want to ask that last question?
So I think, well, there's one last question, but it's very particular. And it concerns an individual who gave a personal guarantee. And then it was scratched out by agreement of the parties. And then later, a creditor engaged in creative Xeroxing and, in such a way that it appeared that the personal guarantee was still in effect. But that seems very particular in terms of the facts. So I'm not sure.
Are we being asked, are we in favor of fraud or are we against it?
I agree. That's exactly what I was thinking, Glenn.
And on that note, we will end this part of the discussion for this ELE and we will turn it over to the students. So
thank you to all the Zoom participants. I don't know if they're still able to hear me, but we appreciate everyone who's come in by Zoom. We hope this was beneficial to you. And I will make I'll make the offer on my own behalf. If anybody has a follow-up question after this, I believe everybody would have my contact information. I'd be happy to, to take questions outside of this context for our Zoom participants.
So when you sign off, when the class is done, when you sign off, and
Okay, fine.
you're in
I
control.
get it. Okay, so now we're in this part of the class. And this is going to be fun. Okay. So what the panelists did was to take your questions and divide them into categories. And so, and obviously the categories: management rights and series LLC, claims of creditors, and contribution required for membership, and practice-related questions. So the format today will be, I will ask at least one question from each category of issues on behalf of the student. Or
we could do that, Julian, or if you'd like to pick one and ask that.
so Esther Kagan's question, I thought, was a good one on management rights.
Hi, Esther.
Hi,
How are you?
good, how are you?
I'm good, thank you.
So we kind of touched on this, the member managed versus manager managed structures. I was wondering what the reasons are for choosing one or the other, and whether you believe that given this new act, companies are going to amend their operating agreements to take advantage of the flexibility that the new act offers.
Let me go first. By the way, we'll all participate in answering questions to the extent we think we can be helpful. And let me go first on that one. And a very broad statement first is the new act probably provides more opportunities than it does problems. In other words, people are concerned about, oh, the law changed. Do I have to change my agreement to comply with the new law? Well, generally speaking, that's not going to be an issue because the act is so flexible that whatever you have in your agreement today probably would still be all right. The question is there an opportunity now to do something different? And as I said earlier, the history behind the whole idea of member managed versus manager managed kind of comes from that history of corporation, partnerships versus corporation. And the reason for choosing one over the other essentially is one of, is this an enterprise where people have come together to be in business together, interacting with each other fully on a regular basis about how they want to run things? Or is this a situation where you've got the inventor genius and you've got some money sources and you've got some people, that are, diverse interests that are coming together. And essentially what you want to do is turn it over to people that you trust to be making the major decisions, in which case, you get managers, you might have a board, and you wouldn't have every member at the table for every situation. You've got the flexibility to design something for your circumstances. And before I give Dan or Jamie a chance to jump in, I mean, is this helpful on your point?
No, it's very helpful.
Okay, good.
So I wanted to add to that a little bit. One of the things that typically comes up, right? And so you consider a situation, for example, where you have three members, right? And all three of them want to participate in management, right? They're three partners, they're 30, each owns a third, they want to participate in everything. Well, so you can pretty easily have a member managed structure there where they all just make decisions on their own behalf. What happens though is typically the members of an LLC, I guess not typically, but oftentimes, especially in the work we do, is the members themselves are entities, right? So you might have a structure where you have an LLC, you have multiple entities as members, and then maybe one of the entities goes up another layer, right? In that circumstance, while you can have, you can have it member managed where the entity is the member managing the LLC, or where you can appoint an entity as the manager itself. A lot of times, most clients from a practical perspective will say, we just want the three individuals who are in charge of decision making to be the managers, right? We want board meetings between three people that we know. We don't want to have to deal with multiple people at these entities. And we want those to be the people who are authorized to sign documents on behalf of the LLC. So that's a scenario where, even though it's practically speaking, it's being managed by those three members, you might want managers nonetheless.
Right. And possibly officers. Correct. That's something that the old act didn't really expressly contemplate. The idea of saying we're going to treat this more like a corporation. You've got the members who select the board, and then the board members put a couple people in charge to run things day to day, and looks very similar to a corporate structure. Jamie, did you want to contribute to this part of the conversation?
I was just going to say, Glenn, I'd be interested in your take. If you have those three managers that Dan had mentioned, do you view them as needing to act with consensus the way that a board is expected to act with consensus? What is your view there in terms of the actual function of that management group? How do they operate?
Well, okay, I guess there's the law and then there's practice. And if you haven't realized that yet, there's a difference between the law says should happen and how people behave in many circumstances. And if you had three managers and your operating agreement says they act by a majority vote, technically, two people could completely outvote the third, and that decision stands. Depending on the working relationships, that's not likely to happen very often. They got together, presumably the three of them trusted each other when they got together in the first place, and will now, follow through, and there should be that consensus that you're referring to. However, I can't resist telling a little story. This is not an LLC story, but a true story from my practice. Many years ago, three guys came to me and they wanted to form, that time it was a corporation, they wanted to form a corporation to start up a restaurant. And I said, okay, one of the things we're going to do when we form your corporation with you three as the shareholders is we're going to create an agreement about what happens if one of you needs to exit the business. Do the others buy them out? What kind of price do you have? Do you have a formula in advance about the price you have to pay to take this person out? And these three guys say, oh, we've all been best friends since college. There's never going to be, it'll be great. And I said, look, my job as your lawyer is to counsel you about things like this. Please humor me and sign this, this buy-sell agreement. And they did. And without exaggeration, it was no more than 6 months before two of these guys came back in and said, tell us again how to get that bastard out of here. So, that's the real world.
I'm laughing because we all have that story, Glenn. Mine was in the dental space, and it was actually within 48 hours of inking the operating agreement that they, yep. I inked the operating agreement, traveled to Chicago for an ABA conference, got a call when I was there, first day of the conference that they were no longer getting along and wanted to figure out how to push out one of their partners. So
I'd like to make an incredibly sweeping statement about the nature of law and human behavior, which is the law cannot solve every problem, at least not to everybody's satisfaction. And you can write great agreements, but when someone just decides they're going to be an incredible pain in a body part, there may not be much you can do about it. I mean, there may be legal remedies, but there's going to be pain and suffering along the way.
and expect dysfunction. I think there's some level of dysfunction in every organization, but do the best as you can, if you're a lawyer, and understanding how to get your clients to effectively navigate through some of that so that they can get to the other side and not get hung up in it.
Shall we
So
get
we're
another
move on
question?
to Series LLCs, and Blake Spiller has a question for you.
Okay,
Hi, everybody. Nice to meet you, Grace. Thanks for coming to speak with us.
our pleasure.
So the new act talks about, being able to categorize these assets into different series. So under the new act, would LLC owners have to respect like corporate formalities of each series so as not to pierce the corporate veil between the other series?
Well, the statute is very specific about the standards that have to be met in order to have the series, the separation respected. And it includes, first of all, you have to include in your organizational document, the Secretary of State's office saying, we have series. So the theory is that somebody who looks at your organizational document will be on notice that there are series involved here. And you have to maintain records that would enable clearly distinguishing the assets. I'm not sure I can recite all of it perfectly off the top of my head, but there is a version in the act of what you're talking about. And I think it's very beneficial to have it in the statute laid out, do these three things and you'll be good. If you don't do these three things, you won't. Okay, so it is right there in the act.
And one other, Glenn, I want to touch on something that you and I discussed when the bill was passed here. And it was let's talk about Series LLC. Obviously, we talked at length about why there's risk in using on a Series LLC, right? To me, and I think your initial reaction was this as well, is what is the utility of using a Series LLC over using an organizational structure, kind of how we do now, of multiple LLCs, many of which are single entity, wholly owned by a parent company, and you divide assets among the different LLCs that way. Because I think at one point we talked about, is there a cost? Is it cheaper, for example, to prepare documents and prepare the records for a Series LLC? And I think when we dug into it a little bit, the answer was no, it would really take the same amount of effort to do either. And maybe even a Series LLC is a little bit more onerous. So I want to hear your view on that.
Well, the theory is by having one entity, there's some administrative simplicity to that. And I guess one thing I haven't actually, or I didn't mention, or I don't think we've made clear is the fact, you can have different owners in different series. So go back to my example of the investment fund that says we're going to have a large cap growth portfolio, we're going to have a large cap value portfolio, we're going to have a small cap portfolio, we're going to have these different investment portfolios, and someone who invests, they select how much they want to put in each one of those portfolios into that silo in the Series LLC, and it's separated. Well, obviously the ownership is different based on who wanted to put their money into which. So a difference between a parent LLC and subsidiary LLCs and the Series LLC would be if the ownership is all up to the parent, okay, it's all going to be the same ownership with assets protected in different LLCs. The analog for the Series LLC in my example would be, let's say instead of being an investment fund investing in marketable securities, let's say you're gonna own commercial real estate. Okay, you could put property A into silo A and property B into silo B, okay, and there might be some administrative advantage, but in my view, you're probably better off just having LLC A, LLC B, LLC C They might have some different ownership, it might all be the same ownership, but they're gonna be kept separate. And you don't have to defend it as this somewhat new crazy idea of the series LLC. Have we been responsive here?
Yes, that's
Okay.
Thank you.
So moving on to contribution requirement for membership. So Florence Van Broek has a question for the panel.
Yeah, so the new act permits a person to be a member without like making a contribution or having like an economic interest. But how do you make sure that a person without a financial interest like acts in the best interest of the LLC?
One reaction I have to that is don't actually have a mechanism to make sure that anybody acts properly. Okay, that was my big speech a minute ago. People may not do the right thing, even though the documents say they should do the right thing. Now, putting that behind us, obviously that person who does not have an economic interest may not have the same economic incentive to do the right thing. But one of the points that Janie made, and is extremely important, is that if you have a board situation or if you're in an entity governance situation where this person is in a role where they're supposed to be exercising authority for the organization, they have to do that for the organization as a whole. So if that person actually understands their duties, they should be doing the same thing they would do as if they own a majority interest in the business. Okay. Now, how do you make sure that they're actually going to do that? If they were put into the organization by a lender who wants to have somebody who can stop the borrower from doing something crazy when the wheels are coming off, okay, then that's a complicated situation because that person cannot represent the interests of the lender per se, but they have to conclude that I think the right thing for this organization is it should not get sucked into the bankruptcy of the rest of the company. How do you make that person do the right thing? Pick the right person.
Yeah, I think pick the right person, but I also think it's a matter of how your board, so to speak, works together. And I think that there can be tremendous power in directors or managers influencing each other to do the right thing. And that's why, I go back to my initial point where if you have an opportunity to serve on a board, absolutely do it, because there's so much power in this collective analytical and decision-making process that you go through on a board. And I've been on boards where we have absolutely been tested, and it could be a situation where someone has a lot of power and they have a conflict of interest, let's call it, but they have a lot of power. And I've been amazed at how the other members of that collective group come together, and maybe individually they don't have as much power, but they come together to then speak truth to power and exert their influence to get that person out of the mindset of acting in their own interest to acting in the mindset of doing what's best for the organization. And even doing it in such a way that the person feels like it's their decision and their idea to act in the best interest of the organization, and they're not even being pressured to do it. So there's just so much power in that group dynamic that I don't know if you can understand by reading about boards and corporate governance. I think you really need to get into the boardroom and a part of that collective decision-making process to understand that.
Right, and when Janie talks about being in the boardroom, she sits on the board of a public company, so she's talking about being there as a director. Many of you are likely to find yourself in a boardroom as counsel to the company and having to try to help with the dynamics in that board meeting. For example, in my case, that was this afternoon. I was in a board meeting where I'm not on the board, I'm just outside counsel to the company. And that can be a very rewarding situation. It can also be pretty challenging when you're not entirely comfortable with what's going on in the room. Now, fortunately, this afternoon, I thought everybody was doing the right thing, I've been in board meetings where I felt like it was appropriate to sort of point out to somebody that they were getting, off the rails. You may, as legal advisor for the organization, you may have to say to an individual that you don't think that individual is behaving in a manner that's consistent with the best interests of the organization. It's not an easy thing to do, but it's why we get paid the big bucks. Well, that's a
Kind of.
metaphor, okay?
Kind of, but there's a lot of complexity, especially in Delaware, around that issue, Glenn, about what do you do if you have a director who has engaged in misconduct in the middle of their term? Because when you look at it from a corporation law perspective, the ability to elect directors and remove directors is fundamentally a stockholder right. The board itself does not have removal authority. So you can be in a situation where somebody is acting very badly, and you have to decide, how do we bring this person under control? Can we have conversations with them? Can we get them to do a midterm resignation? Is that best for the organization from a public announcement standpoint, or does that signal something? So there's a lot to that. If somebody isn't behaving appropriately, what do you do? Or do you call a special meeting of the stockholders in order to remove that person?
Yeah, and the only thing I wanted to add to this conversation too is just that taking a step back from a practice perspective. For those of you who are thinking you want to, go on to practice law, right? Whether it's a firm or at in-house somewhere, what you'll soon realize, and I know I realized it a couple of years out of law school, is that so much of being a lawyer is dealing with people and dealing with emotions and how people act and what their personality is like. And so if you can really master that, I think you're over 50% of the way there, right? And so everything Jamie said about dealing with boardroom dynamics, right? Or even back to your question about someone who doesn't have an economic interest, how do you ensure, that they're acting in the best interests of the entity? I think it all goes back to knowing that person, selecting the right person, and generally speaking, just being able to read people and get them to kind of figure out what the best path is to resolve an issue.
Sometimes in the practice, it almost feels like you're playing the role of a psychologist, as opposed to legal advisor. It really can't come to that. And I can't help but quip. Very early in my career, one of the litigation partners told me the most important thing about practicing law was being sincere. As soon as you learn how to fake that, you're going to be fine.
It's a good one, Glenn.
We have a question now on fiduciary duties from Benjamin Russo.
So I had a question, just because the new law, it allowed for a more comprehensive waiving of fiduciary duties, and I'm just wondering if that's problematic, if you think it's going to lead to some unethical behavior, or if it's just more of a have it your own way sort of.
Yeah, and I think that the answer to that is honestly that it depends. I think that there are certain circumstances where it's entirely appropriate to waive fiduciary duties. You're dealing with sophisticated investors. They have a lot of investments and a lot of business interests, and it's just not practical to have them be bogged down by fiduciary duties. And the corporate opportunity doctrine is a good example where if that applies and a corporate opportunity is brought to you, you have an obligation to bring it to, the organization that you're a part of. Well, if you have lots of organizations where you have that duty, how do you comply with that duty to all of them? It's just not practical. There are.
In my experience, the poster child for that idea is the real estate developer. The guy, what they're in the business of going out and finding parcels of real estate they want to develop. And if they had to treat every one of those as if they had to, let existing investors, any one of them be involved in the next one, it really is just not a way they can operate.
Right. Yep, exactly. And then the other thing is just that I don't view this as a new concept in Ohio. I think that the 2016 statute allowed us to do this. I just don't think that it was a well-crafted statute. And I think that this is a much better version of allowing you to waive. So I don't think this concept is entirely new. I also think when you look at it from a competitiveness standpoint, if we want to compete, so to speak, with Delaware allows this because they want to uphold the freedom of contract between sophisticated parties. And so I think Ohio needs to move in this direction and be in this direction. I think that there's always going to be people who behave inappropriately, whether fiduciary duties apply or not. And if they don't, there might be other courses of action that you can take against that person anyway. So, so I think it's good flexibility, honestly, that can help individuals maximize the result of their organizations and their, their own investments.
We probably have time for one final question from Sierra Pittsville. If you would ask your question of the panel. It's a practice-related question.
Sure. So Gwen already touched on this a little bit, but what are some additional rewards in challenges, either sitting on a board or providing counsel to the board? And on challenges, how do you overcome them?
Janie, you want to go first on that one?
Sure, I'd be happy to. I think one of the most rewarding aspects of sitting on a board is the fact that as lawyers, when you become a lawyer, you can see the legal side of things, but you can also really understand the business side of things. And sitting in that boardroom and working with a team of people to set strategy for the organization, and then working with management to execute on that strategy, and then evaluating the results of what you've done can be an incredibly rewarding experience. I think that the flip side is that you have to make some tough calls if you're really going to do something. You can't just, if you've decided to do something and it isn't working, you can't just keep doing it and thinking that you're going to get better results. You have to make decisions, and sometimes those are really tough decisions. If you look at Peloton, for example, you can see that their board is going through it with their announcement to switch from the founder as the CEO to a new CEO. Going through that process to determine who the best leader is for the organization and asking somebody to step down is a tremendously difficult process. And so you have to be able to make those types of tough calls. And Peloton also made a decision to lay off, I want to say 2,300 to 2,600 workers. That is not a great feeling to make those types of decisions when you're sitting in the seat of being a board member. But, thinking that you're part of an engine of economic growth and innovation, and you're helping to create, in good circumstances, create jobs, create the next great product. There's nothing better than that experience.
Yeah, and if I could comment, at least one of the questions is sort of about the idea of selecting an area of practice. How do you know you want to be a corporate attorney? And I'm kind of, I'm touching on your question, but I think it's closely related to what Janie was just saying. With all due respect to my brethren that are trial attorneys, generally speaking, when they get done doing their job, somebody's happy and somebody else is unhappy. Or they may settle a case and nobody's happy, okay? When Janie and Dan and I get done working on something, someone has bought a business, someone sold that business, they're both really happy. Someone has gone out and got a bank loan, and now they have $10 million more in their company they can use. The bank is making money for making a loan. The borrower is real happy they got the money. Everybody's happy. It is not unusual in corporate trade. It's less common these days, but historically it was very common that after we completed a transaction, everybody would go out to dinner together, toast each other, job well done. And when I say everybody, I mean parties from both sides, lawyers from both sides, if applicable, investment bankers from both sides, the audit partners from the auditing firms from both sides, go out and have a massive, incredibly expensive dinner, okay, and celebrate the fact we did this. And I sometimes say to my trial brethren, I say, so when you guys get done with the trial, how often do you go out to dinner with the lawyers from the other side and their client? And guess what? Never. Okay, so what is it? Obviously, any of you can choose either not to go into the profession. You could choose to go in any aspect of the profession. But my little pitch to you here is if you go into the profession of being a business lawyer, you have the opportunity to help people build things, create value, create jobs, and put smiles on people's faces and get toasted at a very expensive dinner.
Well, that just seems like a perfect way to end the class. And it was so nice to meet you, Janie Chuban.
Nice to meet you too. Thank you for having me.
Oh, it was so great. Thank you, Dale, for coming and sharing your insights. It was really wonderful. And I think that my job now is to end the session on Zoom.
Fair enough.
Anyway, I hope to meet you in person soon.
Likewise. Take care. Take care, everyone.
Laurence, may I see you after class? Please. You submitted a question I